variety of news articles from as early as the early 2000 teens, in which the San Marcos Police Department's records management system was referred to in news articles that were circulated, published at the time. Obviously, in light of Sergeant Tankersley's testimony or lack of recollection about delays in this investigation, the lack of records that he could refer to refresh his recollection, and the testimony that was provided about the existence of that record management system and the fact that those case assignments would be reflected in that system. We believe that that is exculpatory. It should have been disclosed under 3914 and Brady and its progeny.
May I respond, Your Honor?
I just make it clear for me, Mr. Puryear, what is the evidence that you think was not turned over?
Any records that would be contained within that record management system, Your Honor, and it's hard to identify what would be in records that we don't have, but I would expect that that the assignment to CID and to then Sergeant Tankersley, when that assignment would have happened, when he reviewed that assignment and that blotter that he referred to, and the delay in the investigation, why potentially exculpatory evidence was lost because of the willful and unnecessary delays in the investigation from the San Marcos Police Department, either from Sergeant Tankersley or Detective Davidson. It's impossible to run down any of that information without those records, and those records were not provided to us. Again, I can provide news articles to the court, a variety of news articles to the court that cite us with specificity the San Marcos Police Department's record management system that was in existence in well before 2019.
Say.
Yes, Your Honor. We previously had a hearing on this back at the time they filed their motion, and I asked Detective Davidson to look into it. What he found was there was nothing contained in any system beyond what had already been disclosed. There is no evidence in this case that anything was willful or that there's any reason to believe there's exculpatory evidence that is lost or missing because we don't have the assignment of the case to Detective Davidson. What he reported back was that the phone calls were in there. They have the phone calls. That the reports, the documents, they have the documents. There wasn't, like, I think what they're describing, a timeline of things that happened, that isn't there or isn't there any longer. There was nothing for Detective Davidson to go into a computer and find and print out that could be disclosed in this case beyond what has already been disclosed. And that was his representation to me and my representation to the court at the time. Even based on their testimony, I don't have any reason to believe that has changed. And then additionally, Your Honor, the remedy for evidence that isn't turned over is to not admit the evidence into trial. The trial is over. I would think that this is something we should have taken up last week, not right now. Presumably they didn't just discover these news articles right now. I still don't believe that anything has changed procedurally as far as what is available, what is not available at the San Marcos Police Department.
Very good. All right, you're making a record of that is noted, and we are on the record, right, Ruby? Very good.
Yes,
All right.
We would respectfully request a mistrial on as the court well knows, the court has broad discretion and remedies available under 3914 and the Heath decision out of the Texas Court of Criminal Procedure. based on working violations. And to be clear, for purposes of the record, I don't think the DA's office has hidden anything from us that they have in their office possession, but I think under the broad umbrella of the state, including the San Marcos Police Department, that unquestionably fits as records under the state. Again, there's a variety of news articles, KVU News from July 14, 2014, that the department's record management system and received the same investigation and statistical analyses ability as if a report had been filed by a police officer. September 17, 2017, San Marcos City Council meeting minutes references that record management system. Again, I don't believe it's this district attorney's office, but I certainly believe, in light of the news articles that we've been able to find, that they did have that system, but they misrepresented the existence of that system to the district attorney's office. And for those reasons, Your Honor, we would respectfully request a mistrial in this case. That is one of the broad remedies that the Heath decision discusses, and we would respectfully request that at this time, Your Honor.
And just a brief rebuttal, Your Honor, looking at the exact same news article that defense even just talked about, it is actually an article about a new system for taking online police reports, and that those online police reports would transfer into the record management system, which is what was explained at the previous hearing, that we have the documents themselves. It's just that the system at the time was not able to track when a physical file went from one person to another. That's what they're asking for, records of that actual transfer of the file, not any specific piece of information. And so we don't believe that these news articles that they're bringing up even show anything different than what was already explained.
Very well. The motion for mistrial is denied. Are we ready to proceed to closing arguments?
Yes,
Defense is ready, Your Honor.
All right, please bring in the jury.
All right, for the jury.
You may be seated. I will now read you the charge of the court. Ladies and gentlemen of the jury, the defendant, Lincoln Pearson, is charged with sexual assault. To this offense, the defendant has pleaded not guilty. Both sides will soon present final arguments. Before they do, I must give you the instructions that you must follow in your deliberations. First, I will tell you about the general principles of law that must govern your decision in the case. Then, I will tell you the specific law applicable to this case. Finally, I will instruct you on the rules that must control your deliberations. General principles. The indictment. The indictment is not evidence of guilt. The indictment is only a document required to bring the case before you. The indictment cannot be considered in any way by the jury. Do not consider the fact that the defendant has been arrested, confined, indicted, or otherwise charged. Presumption of innocence. All persons are presumed to be innocent. No person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The presumption of innocence alone is sufficient to acquit the defendant. Burden of proof. The prosecution has the burden of proving the defendant guilty. It must do so by proving each and every element of the offense charged beyond a reasonable doubt. If it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. If the state proves every element beyond a reasonable doubt, then you must find the defendant guilty. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Jury as fact finder, you are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. Evidence. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention anything that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the lawyers are not evidence. Evidence consists of the testimony of the witnesses and materials admitted into evidence. You are instructed not to allow yourselves to be influenced by what you may think is the court's opinion in this case. The court has no right, by word or act, to indicate any opinion regarding any matter of fact involved in this case, nor whether the defendant is guilty or not guilty. The court has not intended to express any such opinion. If you have observed anything which you have interpreted or may interpret as the court's opinion upon any matter of fact in this case, or of whether the defendant is guilty or not guilty, you must disregard it. You should give terms their common meanings, unless you have been told in these instructions that the terms are given special meanings. In that case, you should give those terms the meanings provided in these instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits that are justified in the light of common experience. You may make deductions and reach conclusions that reason and common sense lead you to draw from the facts of the evidence. Admitted exhibits. The admitted exhibits will be provided to you for your deliberations. Only exhibits that were admitted into evidence may be given to you. Written or recorded statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Testimony. The court will allow testimony to be read back to the jury only if the jury, in a writing signed by the foreperson, 1, states that it is requesting that testimony be read back. 2, states that it has a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identifies the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in disagreement. Defendant's right to remain silent. Our law provides the defendant shall be permitted to testify in his or her own behalf. If he elects not to testify, that fact shall not be taken as a circumstance against him. You are instructed that you cannot and must not refer or allude to that fact throughout your deliberations. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. Note taking. You have been permitted to take notes during the testimony in this case. In the event any of you took notes, the bailiff will collect those notes prior to your deliberations. You may not rely on your notes during your deliberations. Law 1. Our law provides that a person commits the offense of sexual assault if he intentionally or knowingly causes the penetration of the sexual organ of another person by any means without that person's consent. 2. Consent means assent in fact, whether express or apparent. The sexual assault is without consent of the other person if the other person has not consented and the actor knows the other person is unconscious or physically unable to resist, or if the other person has not consented and the actor knows the other person is unaware that the sexual assault is occurring. 3. A person acts intentionally or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 4. You are instructed that under our law, voluntary intoxication, if any, does not constitute a defense of the commission of a crime. For the purpose of this law, intoxication means a disturbance of mental or physical capacity resulting from the voluntary introduction of any substance into the body. 5. Now, if you find from the evidence beyond a reasonable doubt that on or about the 28th day of September, 2019, in Hayes County, Texas, the defendant, Lincoln Pearson, did then and there intentionally or knowingly cause the penetration of the female sexual organ of Carissa Ellis by defendant's sexual organ without the consent of Carissa Ellis, then you will find the defendant guilty of the offense of sexual assault. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. Rules that control deliberations. You must follow these rules while you are deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. Your first task will be to pick your foreperson. The foreperson should conduct the deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with other members on the verdict, and sign the verdict sheet. You must communicate with the judge only in writing, signed by the foreperson, and given to the judge through the officer assigned to you. You must not conduct any independent investigations, research, or experiments. Do not look up any words. Do not post information about the case on the internet. Do not share any special knowledge or experiences with other jurors. Your sole duty at this point is to determine whether the defendant has been proven guilty beyond a reasonable doubt. You must restrict your deliberations to this matter. You are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. To return a verdict Each juror must agree to that verdict. But jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. During deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. After you have arrived at your verdict, you may use the form attached to these instructions. You should have your foreperson sign his or her name to the appropriate verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. Signed by me, Tanner Neidhardt, 483rd Judicial District Court, Hays County, Texas. Now, the verdict of the jury reads, this is the form. We, the jury, unanimously find the defendant, Lincoln Pearson, guilty of the offense of sexual assault as charged in the indictment. If that is your verdict, the foreperson will sign that line. Or, we, the jury, unanimously find the defendant, Lincoln Pearson, not guilty of sexual assault as charged in the indictment. If that is your verdict, the foreperson will sign that line on the form. State, are you ready to proceed with your closing arguments?
Yes, Judge, just give me a second to set up the courtroom.
Yes, sir.
Judge, can I proceed?
You may.
Carissa Ellis's immediate reaction tells you everything you need to know about this case. Carissa Ellis's actions and words and demeanor immediately after she woke up proves that she's not alive. Her actions right after this sex assault prove that Lincoln Pearson committed sexual assault. Let's talk about it. On September 28, 2019, after Carissa and her boyfriend Nick went to bed in her bedroom, she's awoke and she realizes that somebody is inside her, having sex with her. She's on her stomach, laying down, and she feels it behind her. And so she turns around and she says, I saw Lincoln. And she immediately gets up out of bed, pushes him off, and says, get the fuck off me. She says, don't touch me, don't touch me. She runs to her closet after pulling up her swimsuit bottoms, and she gets dressed, which is right when her boyfriend Nick wakes up, wondering what's going on. She doesn't even stop to tell him what happened. Because what she's doing is she's storming out of that bedroom, screaming, walking down the stairs, going, "Where are my keys? Where the fuck are my keys?" And she runs outside that front door. And what does she do? She calls Becca immediately. Seconds after this assault happens. And what did Becca tell you from this witness stand? She said, "I FaceTimed the victim." And she said, "Lincoln raped you. Get here now. I want to go to the hospital." Carissa Ellis's immediate reaction tells everything. Those are not actions, those are not the words, those are not the demeanors of somebody who just didn't know what was happening. I got confused. No. It's the actions and the words of somebody that was sexually assaulted. And immediately after she goes outside, her roommate Milan comes down, who took the video. We got to see him try. And Milan goes up to her and she goes, "What happened? What's Milan doing?" And she starts explaining to Milan what happened, and Milan goes, wait. "Did Lincoln Pearson rape you?" And she says, "Yes." And Becca picks her up and they leave. And then you heard that Milan and Nick, they actually called the defendant. We don't have a copy of that call. And their memories are a little hazy about what the defendant actually said, but we were actually able to refresh Nick's memory on the stand. You got to hear it, where we got to play the video of him talking to the officer that night. And he told the officer that night that when they called the defendant, he said, "Carissa wiggled her butt against me, so I went ahead."
Judge, that statement nowhere in the testimony or evidence.
You will remember the evidence as you heard it from the witness stand. You will make that decision. State, you may proceed.
And why that phone call is important is because then later that night, Lincoln and Nick were texting. And it makes sense that that's what was said on the phone call, because Nick says, "Yeah, and you told me you had sex with her." And Lincoln goes, "Believe what you want. I wouldn't shut you because you're my favorite turd." If you believe Carissa Ellis, we've proven our case. If you believe Carissa Ellis, we've met the burden to prove all the elements. If you believe Carissa Ellis, the defendant is guilty. This is not a case where you can say as members of the jury, "I believe her, but," because she's proven herself all of the elements of this offense. And here they are. Just make sure we're all on the same page. On or about September 28th, 2019, in Hayes County, Texas, the defendant, Lincoln Pearson, intentionally or knowingly caused the penetration of the female sexual organ of Carissa Ellis by the defendant's sexual organ without the consent of Carissa Ellis. Carissa's testimony herself proves this. And that's why in jury selection, my co-counsel got up and she explained to you the one witness rule. That's why we talk about it. Because one witness alone is enough if you believe that person and that they've proven the elements beyond a reasonable doubt. One is enough. We could have only provided you Carissa Ellis on the stand, and then you said, "We believe her, guilty." But we brought you more. We brought you the roommates, we brought you her boyfriend, corroborate. And they did, even though And we're not going to hide this fact that memories are not perfect. They're not. They were drinking, we know that. But there are things that they do remember. There are things that they could remember when their memory was refreshed. And they were very honest with you with things that they say, I can't remember that. But the things that they can't remember, they're not reasonable doubts. Because the things that they did remember prove our case. This is not a case where you can say, I believe Carissa Ellis, but. This is the analysis that you should go through as jurors when you're actually sitting back there and going, okay, I know we've got to see if these elements were met, and I know that we've got to see if the state proved their case beyond a reasonable doubt. So what is reasonable? Because we told you there is no definition of state exists. There used to be, they are it. You guys decide. And so this is the analysis you have to go through. Is there a doubt that I have? And the second one is the most important, okay? Does it go to an element of the offense? Does it go to an element of the offense? Does this doubt that I have say that one of those elements can't be true? Because I think we can all agree that there are certain things in cases like this we would like to have. We'd like to have Jimmy. We'd like to have photos. We'd like to have the report be taken the night of, and the detective be notified the night of, and then to go to the place and take every piece of evidence and take all the phones and take, every piece of digital technology that was in the house. And that there was surveillance video in the house and in the bedroom so we could see exactly what happened. That's not real. It's not real. And so you have to say, does any one of those missing pieces, does that actually go to one of these elements and would it tell me something different? No. Because Carissa Ellis's testimony alone is enough. And her corroboration by the witnesses that were there is enough. And that's kind of what the defense, though, has been doing this whole trial. Is this table right here? They've been victim blaming, and they've been blaming the officers. I mean, you heard them question the victim. Could have called 911 right away. You could have gotten a DNA swab. You could have gotten the same exam. You could have done this. Could have done that. It's not her job. It's not the victim's job. I mean, you heard from all the experts in this case that said, whatever the victim wants to do, that's what we do. That's their right as a victim, sexual assault. And you heard the reason why. These exams can take anywhere from 2 to 8 hours. Even taking DNA, while the initial swab might be really quick, hours of consent. You can't just walk in and say, I want a DNA swab, and they go, okay, you swabbed, get on out of here. Just work that way. Consent forms. They've got to go through documents just to take one DNA. She even sat on the stand, Carissa did. And this is right after she was talking about being in shock. She said, I was in shock. It felt like my whole body was shutting down. I just wanted to talk to my family in California. Just wanted to talk to my dad. She says, I know I could have done things different. Just because she wishes she could have done things differently doesn't mean that she didn't give you all the evidence necessary to prove this case. And let's talk about law enforcement, because I know that the defense is going to get up here and do it. They should have gone to the apartment that night. They should have had a search warrant for the phones. They might have been able to get a search warrant to force Carissa to do the same. They should have The case should have landed on the desk. There shouldn't have been a 4-month delay. They should have met with the victim in person. They should have taken photos. They should have done a phone call. All of those things could have been done, but none of those things preclude that the elements were already proven by Chris. None of them go to mental ambiguity. None of them are reasonable doubts. And it's important to point this out because members of the jury, this is not a referendum on law enforcement. Okay? Your job is to figure out whether the state proved the elements beyond a reasonable doubt. There are times when cases are brought by bad law enforcement officers. They sit there and they say, I forgot to do this. I could have done that. Happens all the time. Investigations don't have to be perfect to prove a case. Law enforcement officers, detectives, this isn't a referendum on law enforcement. We're deciding whether the state proved the elements of the elements. And so I'll leave you with this. Go back in that jury room and talk about what are the things that Carissa and Becca and Nick said that there's no disagreement. She woke up. She felt the defendant inside. That she got up and screamed. That she ran out of that room. That she ran out of that house. That she called her friend. That she told her friend that the defendant had raped her. That she then got picked up in a car. But before she did, she told Milan the exact same thing. That she went to the hospital. That she saw Sergeant Spanigan. That she talked to Sergeant Spanigan. And she said the exact same thing. All within minutes. The defense is going to say, well, the more you tell the story, the more it's true. No. No. Not minutes after a sex assault occurs. Not hours after a sex assault occurs. She was consistent, she was detailed, and you can believe her. If you believe Carissa Ellis, your verdict is guilty. If you believe Carissa Ellis, Lincoln Pearson sexually assaulted. If you believe Carissa Ellis, there is only one decision you have to make when you get that verdict. And it's which person is going to sign their name.
That's,
Yes, Your Honor, may I have a moment to sit with the court?
of course.
Thank you, Your Honor. Yeah. Ladies and gentlemen, absolutely, the more a story is told, the more we believe it's true. We have, as I mentioned, way back on, what seems like way back on Monday, I have 3 kids, the youngest of whom is a little girl, Gwen, our daughter. And about a year and a half ago, our family went on a summer vacation to Montana. And at the time, she was about 2.5 years old, and she just really couldn't keep up with our older 2 boys, my wife and I, because we whitewater rafted, we hiked, and we rode horses, we zip lined, we did all of these things, and she just couldn't keep up. So she stayed back home with grandparents. We were happy to have a little one-on-one time with their one and only granddaughter. But a funny thing happened. And when we got home, she heard enough stories about what we'd done, about the hiking, about the whitewater raft, about the horseback rides, about the zip line. And she believed that she'd been there. She would tell people about the whitewater rafting that she'd done. She would tell people about the hiking that she'd done, about the horseback rides. And at first, we tried to tell her, look, here are all the pictures of our family vacation. Honey, you weren't there. You stayed back home with Amy and Pops. But she believed it. She absolutely believed that she'd been on the strip with us because she'd heard enough stories about it. And in her head, this was her reality. Even when confronted with pictures from that vacation, she had an explanation. Well, I was off to the side. I was playing with dolls. I was over there. I was playing with the horses. She believed it. I don't think she was telling stories. I don't think she was lying. She believed it. Because the mind is a powerful thing. And it tries to make sense of situations. Folks, and I think that is true. I think what you've heard through this trial is that I certainly hope that Carissa at least believes the account that she provided. But the fact is that in that frantic state and that intoxicated state, she was not a reliable narrator of her experiences that day. She's just not. And even though the state told you out of the gate, this is not going to be, what did they promise you? This is not going to be a he said, she said kind of case. That been true? I would offer you as to the essential element of the element of penetration. Do you have any independent, objective evidence that that ever happened? Has that been presented to you? Not by this table, but by this table. Remember, who has the burden of proof here? Is this table. Has any objective, independent evidence been presented to you on that element at all? No. And keep in mind that that is supporting a very serious criminal allegation, a felony criminal allegation of sexual assault. All you have is Carissa's hazy, alcohol-fueled recollection. That's it. That's what we have. We don't have DNA. We don't have any independent corroborating evidence. None. We don't have the family pictures from that Montana vacation that provide any accountability for the version that she told you at all. They don't exist. And why? Because she made that choice. What I would tell you is that the prosecutors want you to believe that Lincoln penetrated Carissa's sexual organ with his penis, despite not having an erection. And what did Nick testify to? He was very clear about this. Just moments after this alleged sexual assault, when according to the state, he's standing there completely naked in the middle of the room, did he have an erection? No? You think you would have noticed that? Yeah, I would, and I didn't. Does that make sense to you? Does that make sense in the context of the story? It doesn't. Is that reasonable? Even if you're inclined to believe that that was the case, is there, again, any independent evidence that corroborates that? There's not. And I'm going to refer you back to the jury charge. We know she wasn't incapacitated at the time, and this wasn't included in the prosecutor's opening statement. That she was nuzzling her butt up against Lincoln's crotch just moments before this happened. You have those recordings. You can go back and listen to those recordings. We know she wasn't incapacitated because that's the evidence that she heard. And what does he say? Who says get the fuck off of me? It wasn't Carissa. It was Lincoln. That's the testimony that you heard. So we know that she wasn't incapacitated at the time. And that's the reason the prosecutors didn't admit that in their opening statements to you. That's an inconvenient truth that is contradictory to the story that they want you to believe. Now, Aggie's going to get up here and she's going to say that by saying that, by Lincoln saying that, get the fuck off of me to Carissa, that he's just putting on a show for Nick. But what did you also hear at the time? Nick's passed out, right? He's asleep. There's nobody to put on a show for. Why does he say that? Because he's just as confused about what's going on as she is. Why is she rubbing her butt up against me? Right? He is just as confused as she is. It doesn't make sense. So what does Carissa start yelling? Well, that he's doing something to me, right? That he is doing something to me. Because what has just happened? What do we know has just happened? Nick and Carissa had a fight down by the pool, a heated argument. How heated was it? Heated enough that Rebecca leaves. She says, I'm out of here. The mood is killed. They're fighting. They're arguing about a girl. And so she leaves. That's how heated this was. And they went to bed immediately after that argument. And now all of a sudden, Lincoln's saying, get the fuck off of me to her. And so she tries to make sense of what is going on by her brain creating this reality. And so what does she do? Well, he was doing something to me. I'm not saying she's lying. I am saying that her brain, in this alcohol-fueled state that it was in, was trying to make sense of what was going on. And I don't think she thought it was going to go this far. I don't. But then 5 years ago, Nick takes it upon himself to call me when he leaves. And look, he was in a terrible situation. I don't blame Nick. He was in a bad situation, right? He wants to appear supportive of his girlfriend. He wants to appear like he believes her. And he told you that. So he hears what he wants to hear in that conversation. And then this little game of telephone starts, right? And he hears what he wants to hear. And even though no confession was ever made to him or anything approaching that, remember, what are we asking? Knowing everything you know about Lincoln, did he ever say anything to you that approached? Yeah, I had sex with her. Yeah, I sexually assaulted her. Yes, I touched her in any way. No. That's what he testified to. Nothing like that was ever made. So what does he do? Well, we know that he goes and he tells Milan. We know that Milan hears, he can confess to it. And who does Milan tell? Well, Milan tells Carissa, hey, he confessed to it when he hadn't. And so what happens from that point? Well, something has to be done. He's just confessed to it. So what do we need to do? They discuss calling 911, but they don't. Carissa decides not to. Well, maybe let's just go to the hospital. We'll just get STD tests. Except who's there? Sergeant Sparenberg. Now, did she walk up to him, seeing an officer being in a safe space to report the sexual assault? No. He walks up to her, says, hey, what's going on? Now she has to say, well, I've been sexually assaulted, and he admitted to it. And that makes its way into his report. And among the few things that Detective Davidson actually does review, he reads that. And what did Nick tell you? Even though he had never said anything approaching a confession or even a statement saying that they had had sex at all, the story gets out there that he's admitted to it. How do you think that's going to affect the San Marcos Police Department's investigation of Lincoln in this case? How do you think it's going to color that investigation? He's admitted to it. What did he say? Probably that his guilt was just kind of a foregone conclusion. Do you think they're going to go out looking for any evidence that he might be innocent? No. That's it. He admitted to it. We got our guy. That's all they needed to hear. How do we know that she didn't think this investigation would go any farther? Well, she had the opportunity to provide the one thing that would give you answers, objective, scientifically validated information about whether or not a sexual assault happened or didn't happen there at the hospital. Now it's different. If she lived hours away from a hospital and couldn't drive, sure, that's a reason not to have it. If she had shown up at the hospital and they said, I'm sorry, we don't have any more sexual assault kits. We can't give you one. Sure, that's understandable why we wouldn't have it. If they said, we don't have a sexual assault nurse on duty that can give you this sexual assault exam, sure, that's understandable why we don't have it. If it had never been explained to her by Sergeant Sparrenberg or the nurse that was there, the importance of the information that would be contained in that sexual assault kit to be provided to a jury just like you, sure, that's a good reason why we wouldn't have it. None of those things happened here. She was in the hospital. They had the kit. Sergeant Sparrenberg and the sexual assault nurse both explained to her, look, this is what it can be used for. This is what it can show or not show happen. And she made a choice. She made a choice there at the hospital. She just wanted to go home. Even though you heard, even from Sergeant Sparrenberg, how long does doing that take? One swab takes less than the time it takes you to brush your teeth. That's what you heard, even from their witness, even from a sergeant at the San Marcos Police Department. That's how long it would take to provide you with that evidence. But she made a choice to not do it. She left the hospital, and again, I don't think she thought it would go any farther because the sexual assault kit hadn't been done. And she didn't call about it the next day. She didn't call about it the next week. She didn't call about it the next month. What's going on with this investigation? By her own account up here, there was a violent sexual predator that was out there that could have victimized anybody else at any given time. Have you arrested this guy yet? And keep in mind, this is not a stranger that she had to keep tabs on. She's still dating his best friend. Right? Is Lincoln still out of jail? Was he ever arrested for sexually assaulting me? Why hasn't he been arrested? We need to follow up on that. It's not like it's out of sight, out of mind. She's dating his best friend that she sees every day. But yet she never followed up. She never called. She never inquired. It wasn't until 4 months later that Chris Tankersley, Sergeant Tankersley, I guess, wiped the donut glaze off this file for the first time and decided, what are we going to do with this?
That's the first time anything gets done. Folks, that is just. And you heard what kind of investigation Detective Davidson conducted in this case. That your tax dollars paid for. This is your San Marcos Police Department. I can summarize his testimony for you in just a few words, and that's basically doing whatever, fill in the blank. That would have been more difficult than doing nothing, and it would have taken some time to do, so we just didn't bother doing it. That's basically what you heard. Well, calling witnesses instead of bringing them in, that's the easiest thing to do. Is it the best? No, but it's the easiest, so that's what I did. That's what you heard. He cut every corner there is. And he did almost this whole investigation from his desk. When we told you in opening statements that he phoned it in, we literally meant he phoned it in. He did everything from his desk. He wasn't willing to interview those witnesses in person so that he could observe, consistent with best practices, nonverbal communication from them. And you heard Sergeant Sternberg tell you 70% of what we learn in those interviews is nonverbal. It's watching body language. There is a reason we have jury trials in person. There is a reason why witnesses sit as close to you as possible. And that's so you can observe them. He didn't want to do that. And why? Again, that's the easiest way to do it. He wasn't even willing. One thing he could have done from his desk, he wasn't even willing to watch Sergeant Sternberg's videotape statement with Carissa. Too long, don't have time. I'll just read the little one-page summary that he prepared. I trust him. For a sexual assault warrant, he couldn't even be bothered to do that. How long did he tell you his entire investigation took? 2 hours. 2 hours. That's how long he spent on this case before he got a warrant. He just read that 2-page report from Sergeant Sternberg and called it a day. You know, he told you these were all the things that we could have done, right? We could have gone and asked to see if there was surveillance video. We could have done those interviews in person. I could have asked to see their phones, to see if the text messages that I received were actually what was sent back and forth, or they're missing messages. I could have asked the cell phone companies to tell me, were there more messages that were sent that I don't have? He could have done all those things. He didn't ask to get the evidence that he didn't have. And he didn't even take the time to review the evidence or collect the evidence that he did. What did Milan tell you? I told him I have videos that you guys watch. Why didn't he collect them? Well, I put the ball in her court. You are the lead detective in a sexual assault investigation, and you put that responsibility for getting your evidence for your investigation at the feet of a 22-year-old college student. That's her responsibility? You didn't send one follow-up email to her to get those? No, I put the ball in her court. But that tells you all you need to know about Detective Davidson's approach, how he views his responsibility. And if he had a shred of integrity, he wouldn't have blamed Milan. That tells you everything you need to know. If someone else doesn't do it, it's not going to get done. That's his philosophy. That's how he approaches these investigations. If someone else doesn't do it, it's not going to get done. And what did you hear? Exculpatory physical evidence. The kind of evidence that somebody that's been falsely accused would love to provide you. Where does that come from? Well, it's lost forever. When detectives like Detective Davidson fail to be professional, when they fail to be thorough, and when they fail to try, they just didn't even try. That gets lost forever. Where is that exculpatory evidence? It's in the margins. It's where you have to dig to get to. And he didn't even try. 2 hours that he spent on this investigation. And he grabbed a warrant for a serious allegation. Again, spending less time working on this case than you or I would spend watching a Hollywood movie. To get a warrant that's going to change somebody's life for a serious offense of sexual assault. That's what he spent. 2 hours. Now, even Sergeant Stern, their witness, told you, how would you approach this process, getting a warrant in a very serious felony criminal case? Well, that's a big deal. Not what he told you? That's a big deal. Getting a warrant for a sexual assault is a big deal. I want to be very sure before making that charging decision. I want to be sure. That's what you heard. It's a big decision to be taken seriously. And is this a referendum on law enforcement? Absolutely. What did we talk about during jury selection? That's what you would expect if somebody that you know, that you trusted, that you believe would never be accused of a criminal offense, what evidence would you expect to be brought to prove that they had done it? Something weak or something powerful, something compelling, something strong? And we all agreed, there's a reason you are here. We all agreed that he is that somebody or someone for his family. Right? What would you demand to see from this table right here? What would you demand to see? Well, thank goodness Detective Davidson was thorough enough from his desk, spending 2 hours to present this investigation to a judge who isn't even a lawyer. That here's speeding tickets. That's who issued the warrant in this case. Folks, the buck stops with you. He made those choices. Detective Davidson made those choices. Carissa Ellis made the choice to not, again, provide you with that evidence that would be crucial for you to make this decision. By refusing to take that one exam that takes less than the time to brush your teeth to provide you with independent, objective evidence of whether or not what she was saying was true or not. And she did. She made the choice not to. Detective Davidson, he could have been thorough, he could have been diligent, and he could have investigated this case and provided you with the kind of quantity and quality of the evidence that you need to make a decision. Or he could sit around for 4 months, not do what he was supposed to do, let memories fade, phone in his investigation, not look for any additional evidence. He made that choice. And again, while those choices are not yours, those are not your responsibility, you didn't make them, they are now your problem. Because now you have a choice. You have a choice about what comes next, about what the decision is. And I would offer you that, do you choose to convict Lincoln Pearson of a very serious felony criminal offense based on what you heard, or not? That is the choice that you now have. Or do you hold the government to their burden? Do you recognize that This table here is responsible for bringing you the kind of evidence that you should demand to see in a case like this. That is now the choice you have, and because of the choices that they made, that decision is now your problem. What to do with that? You know, despite being told what would be shown in that sexual assault kit or not, she made the decision to walk out that door. And any chance that you had for objective evidence, walk out the door with it. That day, on September 28th, 2019, it left forever. Can never be recreated, can never be uncovered, it's gone. And maybe she did leave because she was tired, even though it would have taken less time than brushing her teeth. Or maybe it's because she knew that deep down, the results of that test would be inconsistent with what she had just described. And that we'll never know. But I do know this, and that is that that burden of proof, that clear and convincing evidence standard that we talked about, that the government would need to take away your kids from you forever. And the quantity and the quality of the evidence that you would demand to see before they could do something like that was very high. Almost certain. That's what you would demand before the state could take your kids away from you forever. And we all agree that the standard you would demand from this table would be much higher than that. Would you let the state of Texas take your kids away from you? Based on the testimony you heard this week? Based on the evidence that you saw this week? If the answer to that question, if there is any hesitation before you say no, I would submit to you that the state has dramatically fallen short of its burden.
Mr. Berger, you have 2 minutes.
Thank you, Your Honor. You know, words and phrases have the meaning that we give them. And we discuss those things during opening, during voir dire, excuse me. Things like the presumption of innocence, proof beyond a reasonable doubt, those concepts have the meaning that we give them. And without you sending a message to Detective Davidson, to this table right here, that you demand the kind of investigation in a situation like this, those words are hollow in the Hays County courthouse. You have to be willing to draw a line in the sand. And that is your job. And it is hard. It is difficult. It takes intellect and it takes courage to do. But I would submit to you that you heard Detective Davidson will continue to play Russian roulette with the lives of anybody that he finds in his crosshairs in any investigation for the rest of his career. What did he tell you? I didn't do anything wrong. I would do it the same all over again. Nope, crushed it. Wouldn't change a thing. Send a message that that is not okay. That for our kids and our grandkids, we demand somebody that will take this seriously, that will care. That's what your message will send to him and to this table. Folks, we want them to care about what they do, to care about the consequences of how they approach those investigations. And that's what we're demanding of you. That's what we're asking of you, is to care about the evidence, to care about what you've been presented or haven't been presented. Folks, What do you not know about this case?
Mr.
What is,
what's your time?
thank you, Your Honor. What is in those missing puzzle pieces that you don't have? We'll never know. And for those reasons, we respectfully request that you sign the appropriate verdict form. And that is that the state of Texas has not met their burden of proof beyond a reasonable doubt. You find him not guilty.
State?
Madam Procedure.
Okay.
We do care. We care a lot. Not just about seeing justice, which is our duty as prosecutors, but about people like Chris Ellis. I want you to care about Chris Ellis also. Chris is not some 6-year-old who got confused about a family vacation. She is a 23-year-old young woman at the time who was violated in one of the worst ways a woman can be violated. And her brain didn't pick it up. It didn't make up her waking up to the sensation of this stranger behind her, on her, pushing into her. It didn't make up the sensation of her bathing suit bottoms around her ankles. It didn't make up the sensation of utter chaos that her body experienced for the next 6 hours. Or so she told you she finally got her body back at some point after she left the hospital that night, after she had thrown up upon leaving after telling her story. And she didn't throw up because she was drunk. 6 hours after she had taken a nap, no. Krista had no choice. All the deflection and victim blaming you're hearing in this case, about how Carissa should have brought you evidence, how Detective Davidson should have done a better job, it's nonsense. Krista had no choice. And you don't need independent evidence. I don't know what he's talking about. You need evidence. Evidence that comes from this witness stand and from the exhibits that are admitted in this trial. And you have a lot of them. Yes, there are things you wish you had. There are probably questions you wish you had answers to. But you are required to look at what you do have, not at what you don't. And the biggest thing, because of the lapse of time, the drinking, whatever, we have witnesses who don't remember. I don't remember is not, it didn't happen. Nick said a lot of I don't remember. He didn't say no, it didn't happen. He didn't say no, Lincoln didn't have an erection. He said, I don't remember. Yeah, I probably would have noticed. Nick also didn't wake up until Chris was already dressed. And so if the defendant had found some first had gone, he's probably already dressed too. Or had his blanket back around his waist. What they said to you from the beginning, from jury selection to opening, powerful proof. There's nothing more powerful in this case than the aftermath of what happened to Krista. This whole day was that roller coaster of emotion that Sergeant Sparrenberg said to you, that even in the brief time, the hour and a half he sat and talked with Krista, he saw that emotion. You hear it in this recording, you got it from the testimony of Becca and Carissa and Milan. And that Milan told you After this day, Carissa was a shell of her former self. Because she made it up. Oh, it makes no sense. And the first thing she said to anyone was to Becca, Lincoln raped me. She was hysterical, she was crying, she just ran out of her own home, calling for help, the first person she could think of. Lincoln raped me. Before Milan came out and asked her what happened, before she had a chance to talk to Nick, before anyone told her what the defendant was claiming actually happened. This was from Carissa in the very beginning. Well, what do we know about him? He'd been hanging out with us all day. Was he jealous? Was he bitter? Was he horny? We don't know. We know that he changed his story multiple times. We know that in the immediate aftermath, he told Nick, nothing happened. Dude, nothing happened. I didn't do anything. We know he then said, well, she wanted it. We know that from Nick's testimony and what he said that day on September 20th, 2019, the defendant did in fact admit having sex with Carissa. And then in January, when Detective Davidson called him, what are you talking about, officer? He literally doesn't remember the day his best friend stopped talking to him. He doesn't remember the day his best friend accused him of raping his girlfriend, which was 3 months earlier. This is deceitfulness. This is lying. This is obviously, I know what's going on here. I don't want to be in trouble, so I'm going to lie about it. And when he got caught, he blames the victim. No matter what happened, you're Isaac. And we know Isaac is someone who slept with Lincoln's girlfriend. Well, you shouldn't date sluts. I think I have to tell you, bud, you're Isaac. No, I'm not. What are you talking about? What's going on? I think I have to tell you, bud. You spawned a whole new evil tonight. You slept with my girlfriend in the bed I was in. I think I have to tell you. Not, no, I didn't. Nick, I told you my story, believe what you want. And you told me you had sex with her. It speaks for itself. It doesn't have alternative meanings. These aren't text messages that have any other interpretation. No, he's not going to say, yes, I sexually assaulted your girlfriend. No one talks that way. No one's going to say that. But his admission to having sex with Carissa and Carissa saying, I didn't want it, that's the case. Right there. And they continue to blame Carissa to this day for the defendant's actions. So what did he know? He knew that Carissa was Nick's girlfriend. He knew it was new, it was fun, it was exciting. Nick had probably told him about this new girl. He met her for the first time that day. First time. Knew that they'd been drinking a lot, knew that Carissa had been drinking a lot. Knew that they were passed out. And he knew that because he already jumped on them. They did not wake up. They might have moved a little bit, they did not wake up, and I said, hey, what are you doing? Did not wake up. They were passed out. He was not wearing any clothes. We know this because his clothes were in the dryer. Milan put them there. He told Milan he needed to have sex. That conversation him and Milan had in the kitchen after Nick and Carissa had gone to bed was, hey, I need to have sex. Do you have any friends? What can we do? Can we go out tonight? We know what he was after. We know he tried to get into Milan's room. And we know that Milan doesn't think he was trying to do anything. But just because Milan doesn't think he was after her doesn't mean he wasn't. And when Milan didn't answer the door, he went back and got in bed with Nick and Carissa, who he knows aren't going to know he's there and aren't going to wake up. He knew Carissa wasn't going to know it was him. And then when she wakes up and she freaks out, he calls her a slut and says she wanted it. You get to look at all of these things together. It's what we call the totality of the circumstances. You don't look at each little piece of evidence independently and analyze it, look at it, and set it to the side and go on to the next. You look at them all together. Look at each one of these things together, and that gives you the picture, the big picture of what we're talking about. So I put up this picture before I talked about reasonable doubt and how there can be missing things. And we still know what's happening. We still know this is a shark. We still know what happened in this case. And so looking at this picture, I would say the shark is the elements of the offense, what we had to prove to you, all right? And the rest of the ocean doesn't matter. You might have a question about what Nick and Chris were fighting about that day. Okay, great. It has nothing to do with what happened. So you have to throw it out. It doesn't matter. The delay in the case. We don't know why there was a delay from the night Chris reported this to Sergeant Sparrenberg to the day it dropped on Detective Davidson's desk. But you know what? It doesn't matter. The defense has you guys looking at these things so closely because if you're busy worrying about things that don't matter, you can't be looking at what does. Defense expert. Not even really sure why he came here today. I never call victims on the phone. Great. It's in the ocean. It doesn't go to an element of the offense. It doesn't matter. Memory, intoxication. These are things we wish were different. We wish they could remember things better. We wish maybe they hadn't been drinking. You know, if Krista hadn't passed out drunk, maybe she wouldn't have been raped. That's not her job to fix that situation. We wish it could be better, but you know what, they aren't. And so you have to, though, even given that there are questions you might have about specific things people remember, or how much they were drinking, or how much that intoxication affects their memory, they were very certain on a lot of the things they told you. The only person who was really, I think, kind of maybe affected most by memory is Nick. But Milan, Becca, Carissa were very sure of the things they could remember. The investigation. Once again, this is a red herring. Yes, you might have questions about it. Yes, you might wish that there were different things that were done. But at the end of the day, it's a puzzle piece that does not actually go to the big picture. Same with the shorts, whether or not someone had given him shorts. I'm not sure in that apartment with 3 skinny little girls where Lincoln Pearson was going to get a pair of shorts that fit him. But it's another red herring. Same with the cameras. Say this had landed on Detective Davidson's desk the next day. He went out to that apartment complex and he got cameras from the office. What was he going to show you? It wasn't going to show you what happened to Chris's bedroom. The bedding. Everyone agrees they were in the bedroom. What was he going to show you? Chris said he didn't ejaculate. There would have been no sperm on those sheets. The bedding would have shown you nothing. DNA. So much testimony about DNA. Once again, he didn't ejaculate. What DNA? What DNA? I'm honestly confused and going on and on about how quick it could have been for her to get a swab. A swab of her vagina. I'm sorry, that's not just something you can do in time you brush your teeth. That's insane. And the safe exam. Intrusive, time consuming. And Chris has told you, yeah, from TV I knew what they were. I didn't want that. Like, she was hyper focused on the STD test. She was like, I believe as Patricia Botero explained, you get into this shop and things just go one in here and out the other. Your body is just kind of like taking over, it's freaking out. Your mind isn't really doing the normal mind things. She could, even if they sat down and explained to her at length how important that exam was, she might not have been able to take it in. But it doesn't matter, because at the end of the day, she didn't get it. And so it's not evidence in the case. That safe exam could not have told you there was sexual contact between them. Without sperm or ejaculation to prove that, which we don't believe there was in this case, there would have been nothing to collect. That exam, and you heard Crystal Schrecker tell you, it's not going to tell you in most cases that there was penetration. The human body expands. It would not have told you if there was penetration. It would not have told you if there was sexual contact. It honestly wouldn't have told you anything. If she had gone through that same exam, and we had gotten the results of that in this trial, and there was nothing, they'd be up here saying, well, this proves it's nothing happened. And Crystal would have told you that's not true. That's not true. They don't actually prove nothing happened. They can prove things happened, and not always. But at the same time, it's still not before you in this trial. It's what we like to call non-evidence. The judge talked to you about this at length at the beginning of jury selection. Your job as a member of this jury is to consider only the evidence in the case before you and the law given to you by the court. Everything the defense has got up here and talked to you about is non-evidence. It is their arguments and their distractions and their
Judge,
red
that's a
herrings.
misstatement. The fact that a safe exam was conducted or refused, that is evidence that the jury has before them. The fact that there were issues with memory, the fact that.
I got you. You will remember what the evidence is that you had heard. You will collectively discuss it when you are deliberating. State, you may continue.
Thank
You
you.
have 2 minutes remaining.
Thank you. So you guys keep this in mind. The evidence is admitted before you, the testimony and the exhibits admitted in the trial. So consent is really what we come down to again in most sexual assault cases. That she's unaware it's happening or she's unconscious. Okay, we got both, right? The entire time she's unaware it's happening. First she is unconscious, and then maybe in those first couple seconds as she's waking up, before she turns her head, maybe she thought it was Nick. Regardless, she is unaware a sexual assault is occurring. And so we admit both of these are in your charge as ways there for there to be lack of consent. Krista was never aware that the assault was occurring until she turned her head and looked and saw him and started freaking out and screaming. Sense in fact, whether expressed or apparent. She told you there was never expressed consent. There's no evidence of expressed consent. They're going to try and tell you by her wiggling in her sleep, she apparently consented to this defendant having sex with her. That's crazy. Even if she had wiggled it in, which there's no evidence she actually did, that is not apparent consent. Because she had no clue he was even in her bed.
And if they're unconscious, don't make them tea. Unconscious people don't want tea, and they can't answer the question, do you want tea? Because they're unconscious.
We believed her body. We get this feedback from juries more often than we'd like. We believed her body. Like my co-counsel said, if you believe Carissa, we've proved our case. There is no we believed her, but. We believed her, but we wanted that safe kit. We believed her, but we wanted DNA. We believed her, but we just wanted something else. No. If you believe her, then he is guilty of sexual assault. It really is this simple.
Ladies and gentlemen, you now have all the evidence before you. You have the charge of the court and you have the closing arguments of the attorneys. It's now your duty to go and begin your deliberations. The deputy will take you there. I'm sending back the charge of the court. This will be your guide. We will be in recess until you reach a verdict. Thank you.
All rise for the jury.
Anything that we need to take up?
Yes, Your Honor. This is going to the defense's motion for a mistrial based on alleged Brady violations, Michael Morton violations. What I have printed out here are the text messages between myself and Detective Davidson back in May, when this came up the first time when we had the hearing. My memory is that I read this into the record at the time. I cannot recall, so I would like to submit this into the record for that purpose, regarding the information I received, what record management system was in effect at the time.
Have you showed it to the defense?
I have not. Yeah. No.
You have that marked?
I do not.
Fence, any objection?
As I presented you.
Right.
No.
So
Call
it'll be
this-
item State's Exhibit
B.
B. To State's Exhibit B, any objections? Mr. Prager. To State's Exhibit B, any objection? For the purposes of it's not an admitted exhibit in the case, but for the record of the case.
Correct, yeah, well, we have no objection for that limited purpose, Your Honor.
Very good. Next, let me ask, due to the need to get everyone moving on this and size of our county and their ability to do it, is there any side that thinks they will ask for a sequestration?
Not state.
No, Your Honor.
Okay, very well. Thank you very much.
Yes, Your Honor.
All right, we're in recess.
I believe the deputy has our contact information, Your Honor. There's a question or
If
issue.
here,
We wrote our numbers down for Swanky earlier. Oh, sorry.
the donkey.
Donkey.
Oh, you already gave it to him?
Yeah,
Oh,
Yes.
okay, if y'all, if he has it, then. we're-
Yes,
Yeah.
Your
All
Honor.
right, we'll be in touch when we hear
Okay.
something.
Thank you, Your Honor.
Thank you, guys. Good job on closing arguments.
Thank you, Your Honor.
thank you, Judge.
All right, we have a note from the jury. It reads, the jury would like to review Milan's testimony regarding her understanding of Lincoln's admissions both on direct and cross signed by the foreperson of the jury. The answer to that needs to be that they have not followed all the requirements in the jury charge to receive that answer. Any objections?
No,
Your
objection.
Honor.
All right, I'll send it back. I'm gonna write it on here and send it back to the deputy. I didn't put this on the record.
No,
Are you ready?
I'm ready.
That's me, but it's been like 19 months since I've done that. Right? All right, we're in the record. Counsel is present. Mr. Pearson is present in the room. We received a note from the jury that reads, the jury would like to review Milan's testimony regarding her understanding of Lincoln's admissions, both on direct and cross, signed by the foreperson of the jury. I propose to respond. The jury must comply with the requirements in the jury charge to receive testimony. Any objections from the state?
No objection.
From the defense?
No objection.
Very good. I will write that on this page and give it to the deputy to take back to the jury. Anything else?
Nothing from the state.
No, Your Honor.
We're off the record.
Can we be excused?
You may.
Thank you, Judge.
I didn't have a second, I didn't have a chance to cancel you. So you're canceled.
You can take it. Thank you. Jury's asking to go home for the night, come back tomorrow. So I'm gonna let them do that. Ruby, let's go on the record.
Yes, sir.
I received the following from the jury. The jury is currently without a decision with no end in sight. We voted to return in the morning to continue deliberations. Is that possible? Signed at 4:59 by the foreperson. So I will let them do that. I'm gonna give them instructions not to talk about the case, anything, the same instructions, and have them come back and go straight to deliberating when all of them are present at 8:30 a.m. Y'all have any objections to that?
No objection.
No, Your Honor.
Okay. Let's go.
All rise for the jury.
I understand.
You may be seated. All right, I received the following note from the jury. It reads, the jury is currently without a decision with no end in sight. We voted to return in the morning to continue deliberations. Is that possible? Yes, it is. But you gotta follow the rules, right? You gotta follow the instructions. Don't talk about this case with anyone. Don't text or tweet about it. Don't put it on social media. Don't try to tell your significant other, this is what I'm facing and I need your help. Don't talk about this case with anyone because we have to protect the integrity of the process. Y'all can go home. Y'all are in charge of the order that you are going to do things and how you're going to do them. Your foreperson will let us know and we leave it in your hands. Y'all are in your deliberations, but I'm going to tell you to follow those instructions. So y'all can go and you will come back in the morning. I'll let you decide if you want to do 8:30 or 9. Why don't y'all just make that decision as a group? 8:30 or 9, get going in the morning and let Domke know. When y'all come in, you will wait until all 12 of you are present and then you will begin your deliberating. So keep that in mind. The other 11 may be waiting on you. Get there for whatever time y'all agree to and it's yours. It's your time. All right. Thank you, Donkey. Y'all have a good night.
All rise for the jury.
Bien. Anything we need to take up?
Say,
All right,
Your Honor.
y'all have a good evening.
Thank you, Your Honor.
thank you, Judge.
We will have your numbers, so I don't know. Y'all need to be here at any particular time, but very good.
Yes.
Y'all have a good one.
Have a good night, Judge.
Y'all too.